All right, this is LAWS12066 Land Law, and this is a recording which I've decided to do in response to a few student queries regarding the 20% assessment. And I have decided that it's probably helpful to have some clarification just around a few points that the assessment raises. The assessment is clearly divided into various component parts. Part A, Part B. Part A is presenting you with a fact scenario, and as is clear from the assessment, you have two tasks with respect to that fact scenario, and that's divided into A and B worth 8 marks and 6 marks. And then Part B, capital B, of the assessment, which is worth 6 marks, requires you to undertake an activity through the PEXA learning environment with regard to creating a document using the National Mortgage Form, and to comment upon that. Now, I'll come to Part B just in a moment, but returning to the first part of the assessment, capital A, which is worth a total of 14 marks divided into two, small a and small b. So you've got a problem-solving scenario there. You've obviously, it's clear from the facts that you've got a transaction involving a purported mortgage in relation to a property that is owned by two individuals. So you need, the circumstances in which they have that ownership, and that property is being used as the basis for raising finance, borrowing money from the bank, from Whitsunday Bank, for the purpose of pursuing some business activity, which is nominated on the facts. The facts also reveal that there's been certain steps and stages followed through, and once those steps and stages have been followed through, then the facts reveal that the interest of the bank has been registered under the Land Title Act. And then we find that there is issues that in relation to that, because one of the owners doesn't seem to be happy with the outcome that his Townsville property, which he owns with his other co-owner, Teresa, has been mortgaged in this way to Whitsunday Bank. So we've got Part A and Part B, small a and small b, within capital A of the assessment. And in the first part, you're being asked to advise Graham, as one of the co-owners of the Townsville property, in relation to the mortgage that's been taken over that property. And you're being asked, is there any issues with that mortgage? And you're being asked, what could Graham do to challenge the mortgage, essentially? So this requires you to think about the nature of the interest the bank has. It requires you to think about the consequences of that having been registered under the Land Title Act, and the sort of protections that would give the bank as mortgagee. But you're advising Graham, who's one of the co-owners, who's a bit, he's upset about this situation because it seems to be information on the facts to suggest that maybe he wasn't fully involved or fully aware of what was going on. So the purpose of A is to get you to see, from the perspective of a mortgagor, is there any way that security interest can be challenged? That requires you to think about the nature of the interest that the mortgagee has, the sort of protections that they have under the Land Title Act once registered, and it also then requires you to think about, well, how could that be challenged? How could that be attacked, if you like? Is there anything in the facts in terms of how that interest got to the point of being registered, which means that there's an issue, there's a problem. There's a challenge there that can be presented, and it can affect the protection that it might otherwise have as a registered interest. You're needing to go back and examine the information, the actions and activities, or the actions and decisions of the various characters in the scenario in terms of what led to that point where the bank was in a position where it could register its interest. Was there any issues that, or any factors that could be raised by Graham as the owner of the property to say, look, no, that there's a problem with this mortgage, and I'm not bound by it. So the first part of capital A, small a for 8 marks, is to get you to investigate the law around that. But also, one of the purposes of the exercise is to contextualise your application of the law into the context within which the facts arise. And one of the implications from the facts is that there's a number of features that involve electronic processes, and you need to think about, well, how far has that gone on the facts as presented in the question, and how does the law that you've studied in topics 2 and topic 3 of the unit, how does that law work in this environment where there is several electronic features in terms of the processes that have been followed and the steps that have been followed in terms of moving towards the bank being into a position where its mortgage can be registered as is revealed on the facts. So there's that part, small a for 8 marks, is requiring you to analyse the law, the legal frameworks that govern that situation, and how might that law be used to give Graham a legal basis to challenge the mortgage as in terms of its enforceability against him and his co-owner, firstly. But secondly, in terms of the way the facts are explained and different electronic dimensions and features of those facts, how is the current framework of law, does that seamlessly apply in that environment? That's one of the things for you to think about, and also to think about how far have those electronic processes gone on the facts. Now, we're not talking about capital B here of the assessment, which is clearly getting you to look at what happens in the e-conveyancing environment under PEXA, okay? But looking back at the factual scenario for capital A in the question, what are the facts? How far have the electronic processes gone? And what are the various types of aspects or features of those electronic processes that are reflected on the facts? And how does the law and the way that the different issues have been discussed in terms of protection of registered interests and how they could be challenged, how can that be used in light of these facts that have a number of electronic features to them, if you like, put it like that. So the purpose, if I can just put this back to folks, again, clarification of the purpose and rationale, is to get you to work with that body of material in topics 2 and 3, and this is essentially, I'm not saying anything more here than is self-evident, within chapter 5 of the casebook, that the framework there of the law, how far can it go in this modern environment? And the facts are also getting you to think about, well, how far does that protection go, if you like, in terms of the nature of the interest that the bank has and that it's been registered. And in this type of a transaction, it's important to appreciate that there are there's a couple of sets of relationships going on here, so that a mortgage is about creating a security interest over land, real property. But when a person borrows money from a bank, from a financial provider, they also enter into a loan contract. Now, there's information in the facts about that as well. So there's these two, if you like, two sets of relationships. There's a relationship between the lender and the borrower, underpinned by a loan contract. And then there's a relationship of mortgagee and mortgagor, which is underpinned by mortgage, which is a security interest in the land. Right? Now, again, the problem question and your specific given direction is not to consider the law of mortgages, which we consider at the end of this unit, the last topic in this unit. So we're not looking at the law of mortgages, but we're using the transaction involving a loan and a mortgage as a way to investigate and to consider the application of the concepts that we're looking at in topics 2 and 3 with regard to interest in the torrent system, what registration gives, how might a registered interest be challenged, the sort of protection that a registered interest holder has, and in the context of, for example, a mortgage, as opposed, for instance, to a fee simple owner, because this is not about a sale purchase transaction, because the owners own the property that is using it as a security to borrow money to do something else. How far does that, protection in the context, for example, in a mortgage, how far does it go? What does it actually, extend to include, if you like? And you might like to think about that against the facts and the perspective of the first part of capital A, small a for 8 marks, is to advise Graham, who's the co-owner, whose property is humanly burdened by this registered interest, this mortgage. How is there any basis upon which he can argue that he is not bound by this mortgage? So that's the perspective with regard to A. Now, we have a couple of queries about, well, is that very different to B, Michael? I think the point of raising small b for 6 marks is to turn your thinking around so that rather than just thinking about it from the perspective of the owner of the property, I'm now asking you to put yourself in the position of advising the mortgagee with Sunday Island Bank. Now, a couple of students have said, well, Michael, you can't advise both parties on a transaction. That's a bit, potential conflict of interest in terms of ethical obligations. So, yes, that's true. But this is an academic exercise, so you're not acting for both sides of the transaction in the one matter. Okay, so be clear about that. But you're being asked to think about the puzzle that's being presented in the fact scenario from different perspectives. That's the purpose of the exercise. So the first one, small a for 8 marks, is getting you to think about it from Graham's perspective as a co-owner being burdened by this registered mortgage interest. Right? Small b for 6 marks is about thinking about it from the perspective of the registered mortgagee, the bank. And again, the focus of the question is whether there is any legal issues which might cause a problem for the bank to enforce its mortgage against Graham and Teresa. Now, what the bank is concerned about really is whether it's done all that it needs to have done, whether it's followed all the processes that it should have followed in making sure that it's duly compliant with the law in securing its interest and ultimately getting its registered interest under the Land Title Act. So the second question is really about you're advising the bank of whether they followed all the steps they need to follow. Are there any issues or concerns in the steps that they've or how they've gone about the process, which will affect the enforceability of their mortgage interest? Even though it's been registered, we need to look at those steps and those processes, and the law does that, and there's specific discussion around some aspects of that in your materials that has emerged because there were concerns in relation to some of that historically. So that's what that aspect of the question is getting you to think about. Also, bear in mind that I am asking you, you can see there, for example, it says, note, in answering part capital A, you are required to refer to and apply current relevant legislation. That means the relevant legislation which we've considered. When I use the word current, what I mean is as amended legislation, which is in its amended form. If there have been any recent developments, any recent reforms or amendments to that legislation, I'm wanting you to think about that. But also notice that I'm also getting you to think about the provisions of the Land Title Practice Manual. Now, not every jurisdiction has a comprehensive guide as we do in Queensland. So I believe it's very important for you as students to consult that resource as well as the legislation, okay? So that's why I'm asking you to consult that. I've given you access to that or hyperlinks to that on the Moodle website. So please have a look at the Land Title Practice Manual, in particular in relation to going through the steps and stages that need to take place in a transaction like this, and does the Land Title Practice Manual have anything to say about that? And also I also talk about any current relevant case law. So, of course, your casebook has a body of case law, but, and you know, when I say but, it's not that case law. Of course, the case law is relevant and continues to apply where the facts give rise to the environment where that case law has relevance. However, just be aware, and this is again one of the purposes of the exercise, if I can provide this clarification, much of the case law, and I hope that you've been able to detect this, much of the case law, if not almost all of the case law, is involving transactions in a paper-based environment, not in an electronic environment. So again, looking for that current case law, but in applying it back to an environment or in a fact situation that has electronic features to it, you need to ask the question, how governing is that case law? Or is there a point where we need to ask questions about how far it can go in giving us a determined outcome, given the fact that the cases were decided in relation to paper-based transactions, and there are, in the facts that you're facing in this problem question, there are electronic features and aspects. So that's something also to bear in mind, and certainly it is part of what I'm trying to get you to think about in terms of this exercise. I've set word limit parameters around the questions. Please keep to those. I'm happy for people to be, you know, my normal practice is 10% either way. Look, I'm not fussed about that, folks. You know, I'm not hard tax in terms of you must on that particular, you know, word that, you know, I'm going to count the letters, count the, you know, the net sense. But if it's clear that you have been excessive in your response, given the word limits, then you'll be penalised for that, because there's a purpose for the word limits. We all have to work within parameters and constraints in what we do as lawyers, and this is part of what this is intended to test as well. You need to be precise, you need to be concise, you need to be on point with regard to the issues you're raising. In terms of setting out your answers, no problem in using subheadings, whatever the legal issues you believe are appropriate. No problem using subheadings, and have an integrated analysis around those. So what's the issue? What's the relevant law I need to consider here? Start working with the facts, and then give me an outcome on that particular issue. Right? We're sort of a bit beyond the sort of the IRAC sort of mentality, if you like, in terms of that's how we set things out. A little bit more, I want you to think about, just in the way that you document your response, a bit more integrated discussion, so that you can tease out the dimensions of the issue as you identify it, and then you can document that and keep within the word parameter, that's what you need to aim to do, because that there's a purpose in that. That's why I'm setting those word limits. And so that again, the overarching purpose of part capital A of the 20% assessment is to test your problem solving skills, to test your access and capacity to use the current framework of law, legislation as amended, current relevant case law, and the Land Title Practice Manual. But again, it's in this environment of a scenario that has electronic aspects to it, and you need to, as I mentioned a bit earlier, you need to think about how far they have gone in the fact scenario in part capital A, and how much the current body, particularly of case law, can be used to respond to those features of the facts. I think it's arguable that certainly the case law is relevant, but how are you going to try and argue it when it's in that different environment, where the cases come out of a paper-based environment and your situation has electronic features to it, right? And that's a matter for you to resolve. And I just want to see, and I'll be interested to see how the various members of the student body thinks about that and deals with that aspect. So if we move on then to the second main part, the second major part of the assessment, that's part B. So we've got here for a total of 6 marks out of 20, and I've divided again this into 2 parts, small a and small b. Now, small a within capital B is, and this is 3 marks, it's just for 3 marks. This is really to let you build the skills in relation to electronic conveyancing as relevant to land law transactions. I think this is a critical skill. I know that electronic conveyancing is not mandated in Queensland currently. Yes, that's true. But it is mandated in 3 other jurisdictions, and there is pushes to move forward. And in any event, despite it not being mandated, the framework is there in Queensland, the legislation is there, PEXA is operational in Queensland. You'll have seen the materials that I put on the Moodle website showing you the various types and features of transactions that can be done electronically in terms of a conveyance and so on, and documents, land law documents, property instruments and so forth that can be done through that environment. So the purpose of Part B, small a, is to let you experience that. And this comes about, as I identify there in the assessment, a collaboration with PEXA. And through this work, CQU is the only Queensland-based university that has developed this collaboration with PEXA to allow you to experience how that is done in for a particular transaction, a particular instrument inside PEXA in a training environment which mirrors the real electronic workspace for completing an electronic documents in PEXA. So this is a sort of a mirror version of what really transpires within the electronic workspace in PEXA. And that's been created by PEXA for people to, students and others, to learn and to understand and practice things. And so they have adapted some aspects and features of the information there to synchronise with my assessment, my scenario, which has been excellent. So the purpose here is for you to take the national mortgage form inside the PEXA learning environment once you've completed the login details and so forth, to populate that with the information from the information that you've been given, and then also to give some thought about any additional terms that might need to be incorporated into the national mortgage form. And this really links back to the information provided in the scenario. You know, do you need to include any additional terms for this mortgage that's involving these mortgagors and mortgagee? And so you just need to think about that. You need to just complete this. I'm not asking you then to actually lodge it through PEXA, because that's a little bit more involved and a little bit more complicated, and I didn't want us to get into that. So once you've got to that stage of just completing and populating the document, just asking you then to take a screenshot of that, what you've arrived at, and then upload that into your assessment. And you know, I'm hoping that most students will be able to satisfactorily complete that aspect and get, you know, quite good outcome on capital B Part A. The purpose of the exercise is to get you to experience that, to practice that, and develop that skill. And in my view, that is a practical, real-world skill that is relevant going forward for lawyering in the future. And it is also showing you how the principles and the concepts that we're looking at from the framework of law now actually exists within the electronic environment and the type of forms that have been created. National mortgage form, for example, is at this point really the only nationally endorsed form in terms of the various transactions and instruments that can be pursued. And it's something there that is developed through, and there's a version of that on the ARNEC website, which ARNEC is referred to as, you know, an overarching regulatory body in some of the PEXA materials. So I wanted to use something that can be done as a standalone document here, which is what we're doing. We're doing a standalone national mortgage, using the national mortgage form to let you experience that and get those skills. So that's the purpose of Part B, capital A. And then I have divided capital B into two parts, so that's for 3 marks. And the second part, for a further 3 marks, is, you know, I wanted to give you the chance to comment on that experience. And I want to see what those comments are. I want to see what you thought about that. I want to see what your views are about mandating this as electronic conveyancing. That's not the situation in Queensland. Should Queensland move in the direction of these other 3 jurisdictions? New South Wales, Victoria and Western Australia. That's a matter for you, and I'm interested to see what you have to say. Some may say no, some may say yes, but I'm interested to see what is the argument that you're presenting, because the purpose here is to get you to think about where things are moving and where they should be moving. So this, yes, I'm looking for your thoughts, your reasons, but also getting you to put yourself in the position of the circumstances that you'll be involved in the future. And so it sort of has a prospectivity about it, but it also has a bit of a you know, real world application aspect as well to get you to think, you know, what should be the environment in which these transactions take place into the future. We have the apparatus, we have the infrastructure in place. What should be the position? So this is an opportunity for you to briefly discuss that. I've indicated a word length there in terms of your thoughts and the points you want to bring there. And I just wanted, that's the purpose of you to, that aspect of the assessment, to let you document your reflections and arguments, the reasons or arguments you want to present in response to the question posed there. Right, I hope that's helpful in clarifying the nature of the purpose of the assessment, what I'm seeking in relation to the assessment, and what I'm hoping that you will reflect in your written responses. So all the best with completing the assessment, and if anyone has any further questions, I'm going to upload this recording now at the end of week 4, and if anyone has any further questions, then just please feel free to email me, and I will respond to those. But hopefully this will clarify the position for anyone that has had some bit of, some uncertainty about different aspects of the exercise. So bye for now.